May 2nd meeting of the Environmental Resources Committee. We'll start with item number 2, the Pledge of Allegiance to the flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Moving on to item number 3, public comment. Reviewing the sign-in sheet here. I have 2 individuals that wish to speak for public comment. We have a 15-minute limit, so given that we have 2 individuals, I'll give each individual 7.5 minutes to address the committee. Just a couple of reminders. Because all of these are in-person speakers, I would just say that when you're called to address the committee, please approach the microphone at the back. Please state your name and your municipality, and you can begin your public comment. I will not start the timer until after name and municipality have been provided, so when you start your comment, that's when the timer starts. Thank you, and now we're going to start.
They have to have surgery.
Ronald Lenz? What's that? Let's? Okay. So, Ronald, if you want to come up to the mic and state your name and municipality for the record, please.
Ronald Lutz, Wausau, Wisconsin.
All right. Just give me a couple seconds here. Thank you for your patience. Oh, we're going to check to see if the microphone is on.
Otherwise, I can yell.
It's all right. Okay. Ron, whenever you're ready.
Good afternoon. During the summer of 2007, my wife and I moved into a new home in a rural subdivision. In 2010, the owners of the property next to ours installed a wind turbine. After failing 3 times, it was replaced in 2021. The original wind turbine noise was disliked and very annoying, but was never as unbearably loud as the new wind turbine that was installed in late 2021. The current wind turbine has completely taken away our quality of life and the peace, joy, and happiness we dreamed of sharing together during our golden years. We are now miserable and living through the worst time of our life. The wind turbine noise has been devastating. The noise has ruined our outside surroundings and invaded and destroyed our dream home. The chronic and persistent noise has also caused damage to our mental and physical health and well-being. The wind turbine noise has taken away the pleasure of being outdoors, enjoying the peace and serenity of rural living, both summer and winter, allowing cool, refreshing breezes to flow through open windows during warm summer days, and relaxing in undisturbed, quiet setting during a bright sunny day. Because of the wind turbine noise, we did not bring patio furniture outdoors, nor did we dine, entertain guests, or have family gatherings outside all last summer. I have recorded outdoor wind turbine noise levels just below 40 decibels to almost 70 decibels. The wind turbine noise can also be heard throughout the interior of our home, significantly reducing the value and saleability of our property. Unfortunately, the interior sound levels are the greatest on the north side of our home, where the master bedroom and additional bedrooms are located. The wind turbine can be heard above a relatively high volume setting of a bedroom television and slightly heard above the sound of a 16-inch fan and a white noise machine simultaneously operating at their highest volume settings. After hearing the wind turbine noise in the attic of our home, our builder made 3 recommendations to address the wind turbine noise inside our home without any guarantees. He suggested adding additional insulation to the attic, adding storm windows to our existing windows, and removing the sheetrock and insulation from the exterior walls of our home, and applying foam insulation into the wall cavities, then refinishing the walls again. 4 inches of cellulose insulation was added to the attic, which to our dismay did not reduce the wind turbine noise level at all inside our home. We have decided to operate fans and white noise machines simultaneously and wear earplugs to dampen the wind turbine noise during hours of sleep when the wind turbine noise is present. My wife cannot tolerate earplugs, so she is putting a ski band over her ears and running both types of fans together at their highest volume settings. I know she hears the wind turbine noise at times. I cannot tolerate the fans running constantly for 8 hours, so even though I am very afraid to do so, I wear earplugs. I slightly hear the wind turbine noise when the earplugs are not firmly inserted into my ears. My greatest fear is that I will not be able to hear my wife if she would be in distress. The furnace stopped operating, the smoke detectors or carbon monoxide detectors went off, severe weather was approaching or occurring, not hearing unusual noise outside our home other than the wind turbine noise or someone trying to break into our home. The piercing, irregular, high pitch and relentless wind turbine noise, both outside and inside our home, has had a profound detrimental impact on our lives, both mentally and physically. We both experienced restless nights, occasionally being abruptly woken out of a deep sleep by the wind turbine noise and unable to fall back to sleep and suffer from sleep deprivation. We both have symptoms of fatigue, irritability, and anxiety. I know I experience anger, bitterness, and a lack of concentration. I would like to have you take note of this quote. The World Health Organization defines health as a state of complete physical, mental, and social well-being, and not merely the absence of disease or infirmity. Infirmity being defined as physical or mental weakness or frailty. In conclusion, then, the wind turbine noise is real, unnervingly disturbing, and substantially beyond all normalcy. I just would like to say if someone here or someone they know is able to provide a professional outdoor sound level study of a wind turbine, please call 715-212-7705. Thank you.
Thank you. So I think our rules are that they have to provide the the name and address prior to public comment 5 minutes before. So I'm going to refer that question to staff. So
Just the address.
I don't believe we're asking for the address anymore, just the municipality or location. So, but I could double check on that. So I don't think we need the actual address any. There.
Not required to, no, but if they choose to,
if they, sure.
I would just like to know.
I think it's Rule 9
Okay,
of Chapter 2.
Let me look it up. Hang on. Yes. Oh, she's listening. There you go.
Oh.
She's got it.
The municipality has to be stated out loud by the speaker.
Yep,
The address is on file with the clerk.
that's what I
Okay.
thought.
Yep.
Okay, so,
So they do not have to speak the address to
Just
us.
asking
Okay.
if they'd like to provide that.
sure. Well, it's one-way communication, so, yeah. Okay. Well, that being said, we're going to go to the other speaker that we have signed up here. So I have Marty Mockton. If you'd approach the microphone at this time, please state your name and municipality.
Hi, my name is Marty Mockton. I'm from the town of Lincoln in Wood County, Wisconsin. My address is 11616 Robin Road, and the address is Marshfield. I appreciate this opportunity. I'm with a group called Farmland First. We formed, I think, 2 or 3 months ago to help inform the public of the dangers and risk of industrial scale wind turbine development. I'd like to thank Mr. Lutz for showing some very real-world examples of the health risks of these very large wind turbines. I became involved with, I guess, industrial scale wind and solar development about 5 years ago. I'm not anti-renewable energy. My wife and I have a 8.8 kilowatt solar array on the roof of our shop. I actually started writing a book about 20 years ago about how I thought wind turbines were going to help save family farms. But when I started reviewing contracts, I'm an attorney. I have about 20 years of reviewing complex, reviewing drafting, and analyzing and advising on complex commercial contracts. I think I've probably done well over $1 billion worth of that work in the last 20 years. And when I started reviewing the contracts, I had never seen more imbalanced, unfair, one-sided contracts in my life. And I was like, what is this all about? Like, how can landowners be getting what I think is such a horrible deal if green is good and these projects are necessary for our energy production? And the more I dug in, the more I realized that I don't think these are truly green energy projects. These are private equity, financial engineering projects in green clothing. And if you look at the company that's developing a project in here in Marathon County, it's Invenergy. The majority owner is a Canadian pension fund called Caisse de dépôt et placement du Québec. Their second biggest shareholder is Blackstone, an enormous alternative investment fund. And I see these deals as shifting a ton of liability onto landowners, not providing a lot of compensation to them, and externalizing all sorts of costs to our communities. We're called Farmland First, our group, because we see this as a disastrous land use policy, and we're also deeply concerned for the future of Wisconsin manufacturing and farms and residences in terms of this being a disastrous energy policy. Our research indicates that residential rates will go up, I think, about $80 to $100 a month with wind and solar projects meeting the goals of the current administration and Wisconsin policy. We also see, actually we don't see, it's the National North American Energy Resource Council predicts that in 10 years, Wisconsin will have the energy reliability of California, or the lack of energy reliability. And we're just trying to sound the alarm that these projects generally do not make sense. One of the concerns we have is very good, reputable organizations that have done tremendous work across the state, like the Wisconsin Towns Association, the Wisconsin Counties Association, and the state itself says that counties and towns and villages and cities can not pass any ordinances or restrictions any more restrictive than the Wisconsin statutes or PSC 128, the administrative code. We have attorneys, and I share the same opinion, that counties and other political subdivisions can pass stricter ordinances. And in fact, I know maybe not everybody here agrees with it, but the town of Johnson in Marathon County last night did pass a health and safety licensing ordinance. We believe that within about a month, 14 to, or a dozen to 24 to 24 townships will have passed health and safety licensing ordinances to protect the health and safety of people like Mr. Lutz and all of the residents in the affected townships and cities and villages. This, to me, is an issue over which we have significant control. I think we need to exercise it. I understand that the county might disagree from a legal perspective of what the county is able to do, but I just ask this committee and the county generally and townships to look at this really, really critically and to exercise the power that we do have. I'm not here to give legal advice. I can't give legal advice to anyone here. That being said, we get the question repeatedly, well, you know, isn't there a risk of being sued if a township does this? I think the thing I learned on day one of law school is in the United States, anybody can sue anybody for any reason at any time for whatever the filing fee is. I don't know if it's $130 now. And we see overwhelming town elector support for health and safety licensing ordinances or zoning where towns have their own zoning. And we just ask that everybody here consider doing more to protect residents. I think we'll see a lot of action on this. I feel like inaction has unlimited risk to localities, both in terms of energy policy and land use, and also unlimited risk in terms of health and safety in the environment. You guys have a lot to say, and I think now is the time to be bold. And I just ask that you listen to your electors. So that's all I have, and thank you so much for your attention and the important service you do. This is the first time I've seen how hard our local government works for little thanks and less money. So regardless of whether you agree with us, we are really grateful for you sitting in your seats and doing the hard work that you do.
All right, thank you to those who spoke under public comment. We'll move on to item number 4, approval of the April 4, 2023 committee minutes. Motion by Supervisor Shapinsky, second by Supervisor Seefeld. Any discussion? Seeing none, all those in favor signify by saying aye. Aye. Those opposed, motion carries. 5, operational functions required by statute, ordinance, or resolution. A, public hearings, review possible actions and possible recommendations to the county board for its consideration, county zoning changes. 1, Tim Vreeland on the behalf of Larry Weigel, rural estate to rural residential in the town of McMillan. I'd ask everyone, including myself, to please mute your phones if you're joining us in person, and if you're joining us electronically, to please mute yourself if you are not speaking. The Marathon County ERC is now meeting in public hearing on the location, plan, specifications, and purpose of the following projects. Tim Vreeland on the behalf of Larry Weigel, rural estate to rural residential, town of McMillan. I would like to introduce the members of the committee. Myself, Jacob Langenhan, Supervisor Seefeld, Supervisor Overbeck, Supervisor Ritter, Supervisor Vinsky, Supervisor Scherfinski, Supervisor Unger, Marilyn Bend, our Wisconsin Towns and Villages Association representative, and Rodney Roskoff, our Farm Service Agency representative. We also have staff present here today, which will assist us for the purposes of conducting the meeting. The establishment of the ERC is required by law for purposes of administration of county ordinances and land conservation programs. This committee must follow state laws and local ordinances as written. This committee cannot change or ignore any part of the ordinances or state laws, but must apply the laws as written. The purpose of this committee is to hear and decide on proposed ordinances and ordinance revisions, rezoning petitions, and provide direction on land conservation and planning programs. The ERC will give a full and fair hearing to any person applying for a rezone petition. A taped recording is being made of the meeting, which will assist with preparation of written hearing minutes. The committee is interested in hearing all pertinent comments and questions. Each hearing will be opened by reading the public notice and allowing staff to present a staff report, including evidence from any on-site inspection. The applicant and anyone wishing to testify will be sworn in and allowed to give testimony. Witnesses will be called in order of those first in favor, second opposed, then third as interested may appear. The committee may ask questions of the zoning staff and applicant. It is necessary that we set a reasonable time limit on individual statements on the overall length of the hearing. To promote orderly discussion, anyone wishing to present oral testimony or ask questions relating to the hearing should state your name and present your testimony or questions so it becomes part of the official record. We request you avoid repetition. Once the committee has all the necessary facts, the chairman will close the hearing, allowing no further testimony, and the committee will deliberate and decide in front of the public whether the applicant has met the standards in the ordinance. No additional testimony from the public is allowed during the deliberation. However, the committee may question staff for purposes of clarification. After a decision is made, the committee will proceed to the next hearing. Many of the decisions made by the committee are recommendations to the Marathon County Board of Supervisors, who will take up the matter at a future county board meeting. Please contact staff for more information regarding this county board process. The committee will now hear the application of 5A1. Tim Vreeland on the behalf of Larry Weigel, Rural Estates Rural Residential, Town of McMillan. And we will begin with our staff report, which will be provided by Garrett. Garrett, I'll swear you in. Do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Go ahead.
All right. Per guidance from the ERC at our last meeting on April 4th, what we're going to do instead of going through the entire staff report, what we're going to do is we'll go through the first page. That includes the petitioner, the public hearing notice, and the notification that the legal notification was made. Then we'll do the staff recommendation and the town recommendation. All right, so this is the petition of Larry Weigel, petition to rezone land, staff report May 2nd, 2023 for the Environmental Resources Committee. The petitioner is actually Jason Flieger at 163-957 Owl Ridge Road, Wausau, Wisconsin 54403. The property owner is Larry Weigel, 112-370 Turtle Road, Marshfield, Wisconsin 54449. The area proposed to be rezoned is located on the corner of County Road E and Turtle Ridge Road. The petition of Jason Flieger on behalf of Larry Weigel to amend the General Code of Ordinance for Marathon County Chapter 17 Zoning Code to rezone lands from RE Rural Estate to RR Rural Residential, described as all of Lot 1 of Certified Survey Map number 11276, located in the northeast quarter of Section 17, Township 26 North, Range 3 East, Town of McMillan. The area proposed to be rezoned is described as Lot 1, Lot 2, and Lot 3 of the preliminary CSM. Parent parcel number 056-2603-1710998. The Town of McMillan Town Board met on April 10th, 2023. Marathon County Environmental Resources Committee is meeting today, May 2nd, 2023 at 3 p.m. A legal advertisement was published in the Wausau Daily Herald. Notice of the zoning change request was also sent by regular mail to adjacent property owners within 300 feet of the subject property. Following are the supporting details listed in the staff report. The town recommendation on April 10th, 2023, the Town of McMillan Town Board recommended approval to Marathon County's Environmental Resources Committee. Staff recommendation, the rezone meets all the zoning district standards as it relates to size, frontage, access, and dimension. The rezone also appears to be consistent with the purpose and intent of the town's comprehensive plan and as indicated by the town resolution. Based on the information provided above, findings of fact, conclusions of law, and the town's recommendation, it appears the rezone request meets all the rezone criteria and standards for rezoning. Therefore, CPZ staff recommend that the Environmental Resources Committee recommend approval to the Marathon County Board of Supervisors. Should this rezone be approved by the Marathon County Board of Supervisors, the town should update its comprehensive plan to reflect the zoning change if applicable.
Thank you, Garrett. Any questions? I have two. The first thing is, why was Tim Vreeland included on the meeting notice? But I see Jason Flieger in the legal description.
So that was a mistake on my part when reviewing the agenda. It had been put in there that it was Tim Vreeland. It is Jason Flieger in a public hearing notice as well.
And I just went and verified that we believe the public hearing notice is what holds the weight, so.
Okay.
The
So
public
notice
hearing
was
notice
sufficiently, oh, wait a minute.
was,
So,
yeah.
Lori, I have to swear you in now. So do you swear to tell the truth, the whole truth, and nothing but the truth?
do.
Everything you just said was factual?
Yes.
Okay, continue.
So that the public hearing notice was correct. It said Jason Flieger, all the notices we sent to the towns, everything like that is correct. So I was told we need to make a note in our meeting minutes that the agenda just listed had an error on it, so.
Okay.
Yeah.
All right. So this was all properly noticed then is what I'm hearing?
Yes, it was
Okay.
properly publicly noticed.
Okay. My second question is, why can't they do the land division in residential estate?
Because they're splitting it into 3 lots. So the minimum acreage for rural estate, which is what the property started as, is 5 acres. So when they split it, they're splitting it into I believe, 2-acre parcels. Let me bring up the CSM here. Yeah, right there. So it started at just over 6 acres. They're splitting it into 3 2-acre parcels.
Yep.
Which means that it would have to go to the next step down to rural residential, which is a
Okay.
2-acre minimum.
Okay. All right. Any other questions? All right. Thanks, Garrett. All right. Anybody wishing to speak in favor of the proposed rezone? And we are under 5A1 for Larry Weigel, the rural estate to rural residential town of McMillan. Anybody wishing to speak in favor, please come forward at this time, address us by microphone, or please unmute yourself over WebEx. Do you know if either Jason Flagger or Larry Weigel are joining us electronically? No? Okay. That being said, I'll call one last time. Anybody wishing to speak in favor of the proposed rezone request for 5A1 on the agenda, please identify yourself at this time. Seeing and hearing none. Anybody wishing to speak opposed to the rezone request for 5A1, please identify yourself at this time. Last call. Anybody wishing to speak opposed to the proposed rezone request for 5A1, please identify yourself at this time. Seeing and hearing none. Anybody wishing to speak as interested for 5A1, please identify yourself at this time. Last call. Anybody wishing to speak as interested for item 5A1, please identify yourself at this time. If no one else wishes to testify for this application, I am now declaring the public hearing on 5A1, Jason Flagger on behalf of Larry Weigel, rural estate to rural residential town of McMillan, closed. The committee will now deliberate on the application and apply the standards of the zoning ordinance. Leave a motion to approve would be in order. Supervisor Ritter?
Thank you. I would like to make a motion to approve the petition of Jason Flieger on behalf of Larry Weigel to amend the General Code of Ordinance for Marathon County Chapter 7 zoning to rezone lands from rural estate to rural residential as described as Lot 1 in the certified map in the town of McMillan.
Motion is made. Is there a second? Second by Supervisor Scherfinski. Any further discussion? Seeing and hearing none, all those in favor signify by saying aye. Aye. Those opposed, motion carries. Thank you, staff. Moving on to 5B, review and possible recommendations to the County Board for its consideration. Town zoning changes pursuant to Wisconsin Statute 60.62 sub 3. We have none. C, review and possible recommendations to the County Board for its consideration. We have none. D, review and possible action. None. 6, educational presentations, outcome monitoring reports, and committee discussion. A, department updates, conservation planning and zoning, Parks, Recreation, and Forestry, and Solid Waste. 1, overview of the Marathon County General Code of Ordinances, Chapter 17, wind regulations, and the Public Service Commission Certificate of Public Convenience and Necessity, and 128 wind regulations. There was a request made by a county board supervisor, and the request was referred to the committee. That's why this topic is being put in front of us today. I requested that staff provide some education on this topic, and I believe we also have a representative from the Public Service Commission that will be available and talk a little bit as well. But I believe we're going to start with Shad, who's going to talk about what the county's role is in this. So, Shad, I'm going to let you get started.
Sounds good. All right.
Actually, one more thing. If anybody from the board, so even you members that aren't on ERC, if you have questions, raise your hand, I will recognize you. Go ahead.
Sounds good. All right. So we just wanted to give a little bit of a high-level overview of Marathon County's wind ordinance and when it applies and what it looks at and things like that. So just kind of starting here. First, I wanted to kind of let you guys know this is right in our ordinance, the purpose of the ordinance. The purpose of this chapter is to adopt and incorporate the requirements of Wisconsin Stats 66.0401 and Wisconsin Administrative Code PSC 128 as a local ordinance and to establish local regulations on the installation, siting, use, and decommissioning of wind energy systems that are authorized by, compliant with, and are no more restrictive than the rules promulgated by Wisconsin Public Service Commission and that serve to preserve and protect the public health, safety, and welfare. So that's the purpose that's outlined in our wind energy chapter in our Chapter 17 zoning code. And how it's kind of broken down is it's broken down by size of system. It's broken down in two sizes, small wind energy systems and large wind energy systems. The way our zoning code views them is a small wind energy system is less than 300 kilowatts. So that would be 0 kilowatts to 299 kilowatts. And another criteria for that is each individual turbine in that can't be over 100 kilowatts in that system. Large wind energy systems, our code identifies them as 300 kilowatts to 99 megawatts. The way it's stated in our code is greater than so it'd be 300 kilowatts or greater. And we'll get to the systems over 100 megawatts in a little bit here. So what does our zoning code essentially look at or outline? So it outlines the application requirements, the filing requirements for somebody looking to do a system like this. Things such as their site plan, a complete description of the project, technical information, project timelines, impact on local infrastructure, and things like that are all included in what they need to supply to the county if they were going to be applying for a system under this regulation. It outlines the local regulations as they relate to abandonment and decommissioning standards, lighting criteria, noise criteria, setbacks, and siting criteria as well. Just some other things it addresses. Again, this is at kind of a very high level here. If a system needs to go through a modification, there's a process in our code for that. Post-construction filing requirements, compliance monitoring for that system, a decommissioning review, appeals, and it also does address complaint process. So where are they permitted in Marathon County? Small wind energy systems are permitted in all zoning districts. If they do come through our office, then we would make sure that they abide by Chapter 17 as well, which is in line with PSC 128. But again, small wind energy systems, so that's the one 0 kilowatts to 299 kilowatts, are permitted in all zoning districts. Large wind energy systems, 300 kilowatts to that 99 megawatts. These are conditional use, so they would need to go through our Board of Adjustments for a conditional use permit. But they are allowed for a conditional use in farm preservation, general agriculture, conservancy recreation, light industrial, and heavy industrial zoning districts. So just kind of discussing now the wind energy systems, 100 megawatts or more. So Wisconsin statute 196.378 identifies the Public Service Commission authority to regulate, place limitations, and oversee permit application approval on these. So if a system is over 100 megawatts, it needs to get a certificate of public convenience from PSC, which essentially means they go through the criteria of making sure it abides by PSC 128 and other standards as well. We do have Stacy Schumacher here. She's the PSC expert, and she's here to discuss. She's here virtually to discuss PSC 128 and Wisconsin Statute 196. So she is kind of on a limitation of time. She can be here till 4:30 with us. So we're gonna hand it over to her. Stacy, are you online?
I am. Can you hear me?
I can. I will kind of scroll through here to get your slides when I know you prepared some. So if you're ready for me to move slides, just let me know.
Sure. Go ahead to start on the first slide. I'll give a brief introduction of myself and the commission. So my name is Stacy Schumacher. I am a policy advisor in the Division of Digital Access, Consumer and Environmental Affairs at the Public Service Commission. I have been with the commission since 2014. This role started for me in November of 2022. Prior to that, from 2014 to 2022, I was an environmental analysis and review specialist So conducted environmental assessments and environmental impact statements on a range of infrastructure projects that came to the commission for review. So I have experience with reviewing large transmission lines, gas pipelines, solar projects. And as I'll mention, we have not had a large wind project come to the commission for review since before I started. I think the last one that came to the commission was in 2011. So that's just a point of context for my background at the commission. As Shad said, that we have 2 levels of projects that we consider when projects come to the commission. Basically, one is the project's over 100 megawatts, and that's a project proposed by anyone, whether it's a public utility or more often we see the larger projects developed, so proposed by developers, such as Invenergy or Nextera. We call them wholesale merchants in the statute. So if it's a project over 100 megawatts under WSStat 196.491, it requires a certificate of public convenience and necessity. On a different track, we have projects come in that require a certificate of authority. Those are projects below the 100 megawatt threshold. And I just wanted to touch on this a bit because this does apply to public utility projects. So if, for example, We Energies was to propose a wind project that was 50 megawatts in size, if it's over a certain cost threshold, which that certainly would be, it does require a certificate of authority from the commission. So we review those slightly differently. And the slide catches some of the main differences between these 2 processes. For example, for a CPCN, we receive an application and we have 30 days to determine whether that's complete or not. So there's an immediate clock that starts. If the project is complete, a second clock, 180-day clock starts for our review of the project. That can and usually is extended to 360 days for a decision on a CPCN project. So if the commission does not make a decision within that time frame, the project is considered approved. So we pretty much never let that happen, and we always try to make sure that we get the projects before the commissioners for them to actually discuss and decide on. CPCN does require technical and public hearings. Agency staff participate in those hearings, as do interveners if there are any. And those cannot be delegated decisions to a division administrator. Those decisions must go before the 3 commissioners at an open meeting. The certificate of authority has a slightly different process. The clock doesn't start until staff start the clock through the issuance of a notice of investigation, but the timeline is shorter, as you can see on the slide, with a 90-day clock, which can be extended to 180 days. Hearings typically would happen for larger projects, but are not required the same way that they are for CPCNs, and can be some of the decisions can be delegated to division administrators. I should mention as well, what's not captured on this slide is that for all construction projects, we have a joint review process with the Wisconsin Department of Natural Resources, Office of Energy. They're the ones that issue wetland and waterway permits and incidental take permits if necessary for endangered species. So we work very closely with DNR staff on those topics. And by statute, we are required to have this joint review process with those DNR staff. And one of their requirements is 60 days prior to submitting an application to the commission. An applicant must submit an engineering plan for them to identify the anticipated permits that are necessary. So that's an additional step before our official process outlined on this slide. Okay, let's go to the next slide. So the CPCN statute describes the findings that the commission has to make when it's reviewing a project. So you can see there on the slide, the commission must make a finding that, based on the record, the proposed facility satisfies needs of the public for electric supply, which that is only applicable to public utility projects. So for example, if a merchant plant submits an application, there are exemptions within the CPCN statute for evaluation of engineering cost and need of the project. And that is outlined very clearly in the statute. But the siting and environmental concerns do apply to merchant plants, and the other bullets on this slide describe some of the findings that the commission has to make in those regards. The projects, so I would just take a kind of sidestep, I would guess, is that we have a requirement to document potential or anticipated environmental impacts of construction projects or commission actions. And that is, the rule for that is PSC 4, and that determines whether a project requires an environmental impact statement or an environmental assessment. That's part of how we build the record for the decision makers. And just in case this is of point of interest, wind projects are generally under PSC 4 are considered type 2 projects, which require an environmental assessment. The environmental assessment is there to determine whether an environmental impact statement is necessary, which is if there are significant environmental impacts. The commission can decide to start with one of those documents if we think it is in the public interest to do so, and there may be significant impacts we need to document. Sorry, I don't have a slide for that, but just in case that's how we study and discuss some of the items that are on this slide. Okay, next slide, please. The commission, so I would say that DNR has very specific permit authority, and they have very specific items that they have to address when they're doing wetland and waterway permits. The PSC has very broad authority over the projects that come to us. We will draw upon other agencies as we think is necessary for the review of a project. We're required to do that with DNR, but we often reach out to other agencies like DOT or DATCAP to bring in some of their analysis. Our CPCN doesn't eliminate the need for other agency permits, so DOT permits are still needed, DNR permits are still needed. So we try to determine whether a project appears to be on the track for compliance with those permits during our process. And then we do include an analysis of comments from the public during environmental scoping periods. And there also is an opportunity for public hearing comments to go in front of the decision makers, which can be members of the public or interveners. And in political subdivisions can request to be interveners in a docket. And then the final bullet on this slide, I'll just say, is that sometimes, for example, DNR may be able to recommend an action, but they cannot require an action based on the conditions of their permits and their permitting authority. However, if the commissioners at the Public Service Commission feel that it is in the public interest for those recommendations to be required for issuance of a CPCN, the commission may make that determination and may require actions that are recommended from other agencies or the public. I think I just have a couple slides left, so we'll get through those. Next slide, please. I know there's a lot of interest in, getting public thoughts and information to the commissioners. These are sort of the main ways that the public can get involved in the commission process. As I said, we often have environmental scoping meetings for the larger projects in project areas. That was paused during the first couple of years of COVID, but we're getting back into doing those in project areas. And staff are available for questions at those times. We encourage environmental scoping comments, particularly those in writing, to inform our environmental analysis. And the environmental impact statement, or EA process, depending on which one we're going through, has in code defined public comment periods. Those comments do not become, I should clarify, those comments go to staff to assist with analysis. Those do not go in front of the decision makers. So if the public wants to make a comment that goes directly to the decision makers, they need to provide it during the public hearing phase of a project review. And that can be done in, a spoken comment or a written comment. Those are weighed the same. It's just whether you provide it in writing or attend the public hearing and are sworn in by the administrative law judge and provide it a spoken comment. And then at the bottom, we do have the ability for people, either members of the public or groups or political subdivisions, to become interveners in a commission docket. That comes with rights and responsibilities. So, there's a scope for providing testimony, but there's also the requirements that come about from participating as a party in a docket. So if you are interested in that, I encourage you to go and take a look at the Commission's website, which has more information on becoming an intervener, roles and responsibilities, and then in some cases, if authorized, intervener compensation, which can be used for things like attorney fees or engaging with experts to provide information. Right, and I think, is there one more slide? Yes, this is what I think may be of interest to this group. There's a lot of questions about PSC 128, and I think it's important to note that when looking at larger projects, the CPCN statute is actually very clear on the interaction of local zoning ordinances and a project that's before the commission for a CPCN. So if you could see the statute written there, if a project that has a CPCN granted by the commission is precluded or inhibited by a local ordinance, it may nevertheless proceed. So I would say, in my experience, often applicants don't even go through that process. They don't go through a local zoning application process because the decision has kind of been superseded by the commission's CPCN process. They would still have to obtain permits for things like road work, driveway access permits, permits that are attached to specific health and safety provisions. But in terms of just your usual conditional use permit or whatever zoning permit process you have, that is usually superseded by this statute. And I think that's all the slides I had prepared, but I'm definitely here to try to respond to questions if there are any.
Hi, Stacy. My name is Jacob Langenhahn. I'm a Marathon County Board Supervisor. I chair the Environmental Resources Committee that's meeting today. I believe I had submitted some questions ahead of time to you for some comments. Were you able to receive those? I think there were 3 of them.
I think.
Stacy, I think the 3 he's referring to, there is one question related to the update of the administrative procedures. That I think that was,
oh, yeah.
Yes, I sent it on last week, I believe. So, yeah.
Yep. I'll look back at that. So In terms of if there's an update to the administrative procedures, that is, so the Wind Siting Council, I didn't bring this up, but so I will say that there is a Wind Siting Council attached to the commission. They have a requirement to review information, peer-reviewed information on human health impacts and policy decisions in regards to wind turbines. And if they have a suggestion for revisions to the administrative code, provide that in a report to the legislature. They are currently working on that. The Wind Siting Council, their last report was done in 2014. Council members did not meet for several years after that, and subsequently missed the 2019 date for a report. They did begin meeting again last year under a new chairperson and have a work plan set up to review literature since the 2014 report and policy changes since the 2014 report, and are on track to have a report to the legislature produced for, I think the work plan says spring of next year. If they find that there are suggested changes to administrative code, that would be included in the report. But fundamentally, any changes to the administrative code would come about through usual administrative code processes. So the legislature could make their suggested or their changes, or they can direct the commission to open a rulemaking. If that happens, the commission has a standard process for rulemaking where public comments are taken at various times through that proceeding. Does that answer your question?
It does.
Or is there a follow-on?
I have one follow-up question, and thank you. That helps tremendously. Is there an opportunity for public engagement during the update of during that process of gathering peer-reviewed material by the Wind Siting Council? Is there an opportunity for public engagement?
There's not a specified role for public comment or input into the report. That's not described in the statute that directs the council to do that report. I would say that if members of the public or local subdivisions have information that they think should be included in that in consideration by the council, you're more than welcome to send it to me. One of my roles is to assist with the administration of that council. So I have often received information over the years or gathered some myself that I've put into a spreadsheet of potential sources that they are in the process of reviewing. So I would suggest, feel free to email me. My contact details are on the commission webpage. If you search for Wind Siting rules, definitely. Let me double check on Wind Siting Council. But yeah, that would be there is not really, in the past, they did not accept comments on the legislative report. That report was completed and sent to the legislature without, a public comment period.
And there is no requirement for the legislature to act on such a report?
That is my understanding, yes.
Okay.
It is an informational report to the legislature.
Okay. And then the last question I specifically have has to do with, and bear with me one moment, I need to jump to a different tab on my iPad here. It's the last slide in the series of slides that you provided with limits to local permitting. With statute reading, if installation or utilization of a facility for which a certificate of convenience and necessity has been granted is precluded or inhibited by a local ordinance. Now, that when it says local ordinance, that applies to any ordinance. It wouldn't be just zoning, correct?
Yes, that's my understanding. I mean, I'm not an attorney and I cannot give legal advice, but my understanding is that, and it's informed primarily through projects from American Transmission Company, like their projects, where they, will say if there's any type of local siting, particularly it's the siting of the facilities or their use, then those rules or ordinances are superseded by the commission's actions. But if you have a rule that discusses like during construction, a driveway cannot access a certain highway, that doesn't prevent the siting of the facility or the operation of the facility. It affects the construction. And it's, it's a rule that still allows for the project to be constructed. It just has certain rules on the actions that can be taken, that those permits are still applied for and are needed.
Okay. Questions? Supervisor Overbeck.
Thank you. I have a question on the citing decisions. It's it states that the commission shall approve an application for a CPCN only if it determines all of the following. Then it has the third bullet down. It says the proposed facility will not have undue adverse effect on other environmental values such as but not limited to. And then it lists out both objective as well as very subjective values. How is that balanced as far as, especially the aesthetics of the land and water or ecological balance? It just seems that those are they're not something that's quantitative the way the first statement reads is it has to determine all of the following. How is that handled like in a public hearing where there's objections to a site for these facilities?
That's a very good question. And I should mention that that slide only has an excerpt of the full statute. I maybe should have made that clear. So if you go to 196.491 3D, there will be additional items on that citing decision, but I pulled out the ones that maybe are the most interest in this context. To answer your question, basically the whole process of reviewing the project and going through rounds of testimony and submittal of an environmental either assessment or impact statement are to build a record to allow the decision makers, the three commissioners, to make their finding on those aspects. So, the aesthetics of land and water, that they will review the application, the EA or EIS, public comments, testimony or exhibits introduced into the record. They will review the record and basically make their judgment on the project and its impacts. They, if you listen to a commission proceeding in an open meeting when they discuss, for example, I think we have that was last week. We had a solar project on the docket last week. They have a tool that they call a decision matrix, which outlines every item in statute, such as these, where they're making that finding and they have a discussion. Sometimes they agree, sometimes they disagree. Sometimes they will impose conditions to get to this point. So they may say, in order to not have an undue adverse impact, we require the applicant to do this action. So they can modify an application as well as either approve or deny it. They have the ability to modify it.
Supervisor Stravinsky.
Thank you. Question that I would have, I'd like to follow up on that a little bit. And the undue adverse impact that I'm wondering about is the impact on adjacent property owners. And that, of course, is both can be very subjective and potentially somewhat objective, but difficult to quantify. But what is the process there, and how is an impact determined, and then whether it is determined to be undue, adverse, or mitigated? What is that process?
Right, that's a good question as well. So how I would describe it is that during a proceeding, members of the public can provide comments. It might help if you'll allow me to walk through an example. So for example, recently we've had a lot of solar projects, and in a couple of instances, members of the public have written very specific targeted comments that go to the commissioners, and they describe their property or their interests and the project and their concerns about the impacts of a project, and whether they think that those concerns can be mitigated or addressed in a specific way. So for one example, there was a landowner, an adjacent landowner to a solar project that was concerned about stormwater runoff onto their property, and they requested that the commission require the avoidance of one of the power blocks of a solar array, the one closest to their property. And they outlined the reasons why. They talked about soil type, they talked about the topography, and they talked about like the location of their mound system. And the commissioners will review those comments as well as all the other evidence in the record. And then they basically, on the weight of the evidence, will make their decision. So in that instance, they thought that the argument was well made, and they required the applicant to work with that landowner to adjust the layout of the array to avoid that impact. So it's all of it is very case by case. All of it is needs to be made based on the record that's in front of the decision makers, the three commissioners.
I have a follow-up to that supervisor's question.
Yeah.
The conditions that are imposed by the commissioners on that project then are binding?
Yes, I will say that there are times when they intentionally will, yes, the conditions are binding. Some of the conditions may have language that is less, how do I want to say this? So some conditions will say work with or as applicable, right? So they'll say work with the landowner or adjust the or as feasible, install screening vegetation as feasible, which, isn't an absolute direction, but the conditions themselves are a requirement for those CPCNs to be valid. So if they say, you must have an X foot setback, or you must avoid putting infrastructure in this area, yes, that is a requirement
Thank
for
you.
that CPCN to be valid.
Thank you. Now we have our county board chairman, Kurt Gibbs. He has a question.
Thank you, and thank you for the presentation. The question I have, I think I know the answer to, but when the application is made, is when the determination is made as to whether or not a certificate of public convenience and necessity or a certificate of authority is needed? Is that correct?
The application will describe the project, and the conditions of the project determine which of those tracks it's on. The applicants always, very rarely have we had an applicant come in with a project stating they think it's going to be reviewed under CA statute, and then we go back and say, no, you should be submitting this under a CPCN. That's the, we do have pre-application meetings with the applicants, and we try to hammer those questions out ahead of time. So they will submit their application and say, we're submitting this application under WSStat 196.491 for a CPCN, or they would submit it and say, we're submitting for a certificate of authority under 196.49.
But in essence, the requirement is the 100 megawatts or larger does require a CPCN.
Yes.
And less than would potentially require a CA. Is there any time when a project is presented that or proposed with a CPCN and then because of size or restrictions put on by the Public Service Commission, move down to a CA?
I have not seen that happen. No. So this is probably relevant. So one of the, and I apologize if I appear to be jumping and bringing new things in, but there's so much to cover with it. So one of the requirements of a CPCN application, they are required to provide alternatives. Now, in the case of like a single gas plant location, they'll give us like 2, maybe 3 locations. In the case of larger projects like wind and solar, the commission has found that it is reasonable for an applicant to provide an additional 25% siting area. So for turbines, like if they have a certain number of turbines, they have to, like each turbine with its megawatt size, they have to provide an additional 25% for the commission to basically make decisions and say, this turbine is okay, these turbines are okay, these are not, you can use these alternatives. So it's a very complicated process of discussion when it comes to weighing particular impacts. And again, they do find that some of those are not in the public interest. I'm going to use solar again as an example, just because we haven't had a wind project come to the commission since 2011. But for example, with solar projects, which also require additional 25% additional acreage or size, I was reviewing a project that had a potential to impact a historic site. And we presented that information to the commission, and they found that it was not in the public interest for the applicant to use a specific array that was, the highest risk of impacting that historic resource. And so they directed them to avoid that area. But because they had the additional 25% extra project area, they were able to make up that difference. And I don't think it would be the case that a project would drop below that threshold based on, that would be a very, I don't know if they were running into that many problems. It's very speculative, but like that would really question the entire feasibility of the project if they couldn't make it work with the additional alternative arrays or turbines. Does that answer your question?
It does, and I did see that project and the CPCN that was in a neighboring county in that solar project, and the PSC did direct to use alternate land on some of that project. Thank you.
Mm-hmm.
And I had another question then. I think it's PSC 128.33 sub 3, and I do want to clarify, I'm not an attorney either, but it does address monetary compensation to non-participating landowners, and it gives the thresholds for the proximity to the site of that project. And I know that there is language in there talking about CPI or 2%. Has there been any discussion thus far in the Wind Siting Council about even updating those base amounts for additional compensation?
No, not at this time. The council is looking at policies as well as peer-reviewed information on health impacts. So whether that is one of the items that they will pick up on, in addition to the table that outlines like setbacks and noise and shadow flicker, it has not been in the past brought up.
Okay. Any other questions? Supervisor Shafinsky.
Thank you, Chair Langenhan. I'm a little confused, and maybe my information is incorrect, but I'm under the impression that a wind farm was brought online within the last year in Grant County, but yet you keep referring back to nothing has come before the commission since 2011. So help me understand that, the apparent confusion there. The project that I'm referring to is Red Barn Wind Project?
Yep, Red Barn is 99 megawatts, and it's proposed by an independent power producer or wholesale merchant plant, so it did not come to the commission for review because it was less than 100 megawatts and not proposed by a public utility. So in that instance, it goes through local permitting processes.
Any other questions for Stacy? Supervisor Sandelsky?
Yeah, thank you. First, I'd like to thank all the people that came here and gave public comment. Okay, I'm looking at the 196.491 on the proposed, kind of the same, we're kind of on the same thing. I just got a different question. On the proposed facility may not have undue adverse impact on environmental values and but not limited to. So for as far as liability, if these wind turbines end up going up and they have impacts on, say, the ecological public health welfare, like who's hold responsible for that? Would that be the wind company or like the landowner, say like the neighbors, as far as they had impacts on their health and that welfare? Ecological, balance. I mean, all that stuff. Like, who takes the liability for that? Is that would that be as far as would that be the wind company or would that be the landowner or a government body? Or I'm just trying to figure that out as far as if it happens and as far as lawsuits come down that way. Thank you.
Yeah, sadly, I don't think I can answer that question. It sounds like a legal interpretation question, and I'm as a staff person, I can't answer that particular question. Sorry.
Other questions from the committee? Last call. Any other questions? Stacy, we appreciate you being able to join us this afternoon, and looks like you'll be able to make that 4:30 commitment.
Supervisor Longenhan.
Yeah, it was my.
Go ahead, Stacy. Sorry.
Oh, go. No, you go ahead. Go ahead.
I was just going to add that you had mentioned that people could email you things for the Wind Siting Council. We did bring up the webpage with her email address on it. So
Excellent.
She said she could share those comments related to the Wind Siting Council, and we can put that in the minutes as well. So,
Thank you.
That was exactly what I was going to say. So my details are on the website. If people have comments or questions, either about, wind siting council, wind siting rules, or just the commission process overall, feel free to reach out to me. If I cannot answer your question, I can usually try to find a commission staff person that can, with the proviso that, again, we don't give legal advice, but if it's something we can answer, I'm definitely happy to be the liaison and try to facilitate getting information out to the people that need it. So. Thank you for giving me the opportunity to speak with you today.
Sure. Have an excellent rest of your afternoon.
Thank you. Bye-bye.
All right. So staff has provided their presentation. We've had a presentation from the Public Service Commission. Anything else for this topic? Supervisor Overbeck?
Yes, thank you. I'm just wondering if there's any set standards or best practices with wind farms as far as what noise standards are, how long, if it's a wind or noise that goes on constantly, what are the standards out there? If there's any guidelines that, instead of reacting to what they're proposing, that there's a best practices manual for how to design one that doesn't do the adverse effects, and how a local government could not necessarily regulate it, but be an advisory board that looks towards that for their residents.
So I think Shad can provide an answer there, but Shad, correct me if I'm wrong. If it's something within the county's jurisdiction, we can, I'm guessing it's regulated in that ordinance already. As for the larger projects where it has a certificate of need, I know in my notes here I wrote down that PSC 128 does address noise. So any sort of input regarding the noise of that project, that would have to be provided to that wind siting council, and then they would provide that report to the legislature, who would ultimately update that code at the state level. But I'll let Chad, like I said, correct me if I'm wrong, but that's my understanding.
Yeah, that's my understanding as well. I can say for noise criteria for the county's ordinance, for example, it states wind energy systems may not exceed 50 decibels during the daytime hours and 45 decibels during the nighttime hours. And it does give criteria as far as how and where that's measured. And it is consistent with PSC 128, so I'm assuming that the PSC, when they do their determinations, they would use similar numbers like that. So.
Yep.
You know, the concern I have is 40 decibels at a, instance is a lot different than 40 or 50 decibels constant. And I guess that's something that, can we look at, is that possible that we update our zoning code to address that? Because what I heard today, even from an individual that says, this is unrelentless, it just keeps on going on and on. If I had that in my backyard, I'd be out of that house so quickly that, it's a situation where it's unbearable. And I think there's a difference between, even noises at night or a highway sound or whatever, it stops at points. But if it's consistent, it's a public nuisance at that point.
So as far as that goes, we can definitely look into it. The one thing I would add to that is we just have to make sure that it's consistent with PSC 128. It can't be more restrictive than PSC 128. So depending what how that would lay down, we can look at it, but it may or may not work.
And in addition to that, sorry, yes, okay, yep, okay. When was the last time that our code was looked at for wind?
For wind, I believe, was it 2000?
I think this was brought into the code at around 2018 or 2019.
Yeah.
We had a time frame by which we had to adopt a wind ordinance.
At that time, there was a system that was under the 100 megawatts proposed. So that's when the county decided to adopt an ordinance. And that's the ordinance we have today.
So for that under. Oh, go ahead, Chair Gibbs.
Sure, there was a project that was being proposed in the town of Eau Plaine about 5, 6, 7 years ago. In fact, there's still land in the town of Eau Plaine that's under contract by that company. Now, I do understand that potentially that has switched hands between the developer and now a new developer, and they've expanded the scope of that project. So it may increase in capacity, but originally that capacity of that project was under 100 megawatts.
Supervisor Stravinsky.
Thank you, Chair. Question that I have is we seem to have a little bit of a gray area when you get into public safety and health. And radiated noise level certainly comes under safety and public health. What is the direction there for public statutes, PSC versus local control? Is that something that we could conceivably regulate to a lower level below that 40 decibel level, and duration?
So if I'm understanding your question right, you're essentially asking if there's anything we can do for if there's a public nuisance, the procedure that we have in place, correct?
Not public nuisance, safety.
Safety?
Because if you think about it, you look at what happens for safety regulations on job sites, whatnot, worker regulations, decibel level certainly comes under safety. That's not a nuisance at that point.
Gotcha. Okay, so right now, with that example in hand, we'd have to stick with what our code says related to the decibel levels and whatnot. I will say in our process here, there is a complaint process where an individual could, it lays out the process in which they would need to issue a complaint to the regulatory agency, whether that's PSC depending on the system or us. So that's an avenue they could take. As far as public safety, there is during the conditional use process, depending on what system type it is, and they can make standards associated with public health and safety. There has been some case law associated with it, and I can't recall the actual case law case, but I can definitely get that out for you guys. But it basically says if you're going to use the public safety standard, you can't make a blanket statement. It's got to be a case-by-case basis. So you would have to look at all the information associated with that project and determine if in that process you might be able to get something in the BOA or the conditional use permit.
Chair Gibbs?
Chad, you were referring to the Eckert Brothers case of 2009 that went all the way to the state Supreme Court, and it was cited and is cited many times when entities or governmental entities try to regulate above and beyond or put in standards more stricter than PSC 128 spells out.
Thank you.
Supervisor Sandelsky?
Yeah, I got another question as far as the safety. As far as like the Flight for Life, they're going to be really restricted as far as their flight patterns and that. Is there anything I don't know as far as we can do about that, or?
I don't know if I can answer that question accurately. We'd have to look into that one a little bit farther.
Okay, I just had one other comment too. I've been doing a lot of research on this stuff because I've had quite a few constituents contact me. They actually in New Jersey, just recently, they halted offshore wind turbine farm because of it was killing so many whales. So, I mean, there's so many. The effects are so deep, and it's just crazy. That's why I feel like we got to do something to halt this as far as on the county level, because it's so destructive as far as health, as far as the ecology, the ecosystem. I mean, just layers upon layers. So, thank you.
Mr. Chairman, I have a comment. I don't know if it's on yet.
You're on. Yeah, it's on. It's on.
There is something in the restrictions about being close to airports and military bases, that there is restrictions there. And so there are some restrictions for airports and military bases. I don't know about local airports or anything like that. You'd have to get more research done on that. Thank you.
So as far as the county's role in this, though, we already have an ordinance for the CA projects that are less than 100 megawatts. As far as anything that's over that 100, where you have the certificate of need, that is a matter for the Public Service Commission that I do not believe that we have authority over. So like a lot of things with the state, there are some things that when it comes to local control, we sure would wish sometimes we would have a little bit more over, but if it's above that threshold, we cannot deny this. It is clear in the rules. Therefore, I think we need to look at what we can control in all of this and have an honest discussion about that. That's why I want to have the experts come in today and have an honest discussion.
Chair,
Yes, Supervisor.
this is Supervisor Mass.
Yep, go ahead.
As much as I'm in favor of renewable energy, I have issues with what is going to happen if this takes place when everything fails and everything's deteriorating. Do we have any control over what is going to be done with all the junk left over? Because I have been doing some research too and find that a lot of these places get abandoned and we're stuck with all the crap left over. I've also seen pictures where shards have come off of blades that have gone into farm fields that are being harvested for cows or being used as grazing for cows or livestock. So do we have any say in any of this, and how do we as a county deal with the crap left over when all this is done? Now, it's going to be not in our lifetime or my lifetime. That's my question. Thank you.
So I think that question could have been posed to Stacy, and you could, of course, follow up with Stacy and ask them in regards to PSC 128. Shad, can you comment on anything that's in our existing ordinance in regards to the regulation of that material?
Yeah, so our ordinance does outline abandonment and decommissioning. It does also outline financial assurance that would need to be put in place associated with that. So depending on the project at hand, it's hard to say exactly what would happen to that without having an actual project in hand. But there are regulations in our code that would allow us to have a decommissioning plan associated with the funding to complete that plan.
Would the chair be willing to recognize me because I have...
This is the committee's meeting, so I'm not recognizing members of the public at this time.
I understand.
Any other questions from the committee? Discussion? Mr. Roscoff.
A lot of these rules were made, when these towers were smaller, as far as kilowatt, megawatts, and height. And now we're talking about, doubling the size and height, blade length, all that stuff. I mean, is there a way that we could, I don't know, put a bug in someone's ear and that the laws or rules need to be changed?
So there it's a matter, and like I said, I wrote this down with the Wind Siting Council and preparing that report for the legislators to act on. Anybody else have anything for that? No? Supervisor Overbeck?
I'd just like to say that also that there has to be a starting point, and I think locally, legislators are politicians that don't know it all. And there's experts out there that need to start talking about this. And public commission members, it seems like there's 3 people with some very subjective, decision-making based upon what public input is. But what we're hearing, and now there's data on all of this, 40 decibels at a constant volume, or 45 and 50, which is what we allow. What does that do to the public, to be the healthiest and safest county? I mean, basically, what are we doing? I think it's time to start talking about this, and this is probably a committee to do that. We're not going to change it. And there's rules and regulations, like everything, but rules and regulations get changed because of happenings and what occurs. As an architect, I look at that, and the building committee changes the codes every year to adjust for what the changes are in the communities and what is being changed as way that we live. But I think this is, it's coming to Marathon County. We need to look at it. And if it adversely affects economic development, it adversely affects, how they're going to get rid of these facilities, just like what we've done to the cell phone towers, as far as they now have to put up bonds and whatever to take them down. That is a huge facility, and there's many of them out in the fields, and some have deteriorated. So I think we have to be very careful on moving forward and do it right. Then I think it's, it will satisfy our energy needs as well as how we live in our county. So I think it's the time to start talking about this seriously.
Supervisor Shafinsky.
Just wanted to add a little point of data. As an engineer, I always look at numbers. Everything else is an opinion. So, we talk about 40, 45, 50 decibels. We had comments earlier. Basically, our meeting here would probably fall, and we are amplified, so that may be beyond that. But typically, an office space would be in the 40 to 50, perhaps with amplification, 60 decibels. So that just kind of gives everybody a reference that what we're talking about potentially is what we're experiencing right now.
Supervisor Sandelsky.
I just had a question, like as far as like, cause these wind turbines are much bigger, as far as maybe if the county could maybe try to get the state to do something like write a resolution for like your distances and stuff, because these are so much bigger than the old regulations were for like 200 to 300 foot turbines, which these are 660 to 1,000 feet, which we may be increasing the distance. It's like 1,250 feet from a house, so it's very close to a house as far as the height of the turbine and the noise. So I mean, maybe we could have a resolution to try to help the state. I mean, we can't write the law or whatever, but maybe we can try to do a resolution to try to get the state to do something. Thank you.
So I'd say a couple of things to that. The first thing is that it sounds like that Wind Siting Council is already in the process of updating those things. The standards in PSC 128. The other thing is that I think we have to be careful, and I'm not naive enough or not stupid enough to not say what's political. So I'm going to say this. When you talk about resolutions as a county board, you're asking the entire county to take a position. And when you do that, you might have some areas that feel differently about it. So in a sense, when you're sending that message to the state, which if the state isn't even going to take this up until the Wind Siting Council has completed its work, and they find out that it wasn't unanimous either, well then, how is a legislator supposed to use that in order to make a decision regarding those rules? Chair Gibbs?
I think what we're referring to is I think the Wind Study Council is going to take professional studies and professional information to heart when they look at this. And if at some point there is an application, then the county can can intervene if it has information that it wants to share that has been vetted, that is official, to be able to provide as an intersection when that application is reviewed by the Public Service Commission. So that would be my suggestion. Allow the Wind Study Council to do its work, because it is under state statute required to do an update every 5 years, as was told. They had not done anything since 2019, partially because of COVID. They've reconvened. They're looking at having their update in 2024. Those updated requirements may address the size of these windmills actually growing. And then there's actual, documented information that, what is going to be looked at. If that isn't the case and we have clear information, we can be an intervener at the time that there's an application. We don't even have an application at this point before the Public Service Commission on a wind farm at all.
Supervisor Overbeck?
Then I see no purpose for the county to even address this at this time until actually that happens, because there's nothing to discuss. It falls underneath our wind ordinance, and what we're saying is we have no say in this. It's legislated.
Above that threshold.
Right. But I mean, there is no reason to have this on an agenda at this point, because we cannot do anything until that's redone, the regulations. It's out of our hands. And that should be made clear to the general public.
Like I said, maybe I was a little bit blunt earlier, but this committee, in regards to another topic that came before this group last spring, you all definitely know how I feel about resolutions coming from this county. I don't think that's a secret. I think that there's a purpose behind sending some sort of a resolution out there. I think that they do have consequences and they're not just a meaningless piece of paper. And in regards to this particular item, if it goes above that threshold, again, I think there's a lot of us in this room right now that don't like the rules, right? But here's the thing. We aren't the decision makers that make those rules. The legislators that we elect are the ones that make those rules. So if you want to see an impact on the rules, call your legislators. I mean, I was at some of these meetings held this past spring. I mean, there was hundreds and hundreds of people there. Legislators, they pay attention to the phone calls that they get. If they get 100 phone calls about a particular issue, they're going to pay attention. You know, I just don't see how the county would gain anything from doing something like that. So, anything else? Supervisor Shavinsky, you're reaching for the microphone.
I am. Just a question. Do we have any background information? Because it clearly is a hot topic, so to speak. You know, we don't even have an application yet. We spent a lot of time discussing the pros and cons and possible impacts on something that we may or may not have any input or ability to influence. Where are the rest of the counties parked? Do we have any information about either our surrounding counties or the Wisconsin Counties Association? Are we alone in this, or are we the outlier, or are we part of a pack?
I'd refer that to staff. Oh, Chair Gibbs.
Thank you, Mr. Chairman. I did provide, the Wisconsin Counties Association had 2 educational sessions provided by the law firm, Atolis Law Firm, who happens to be the law firm that represents, council that represents the Wisconsin Counties Association. And they specifically were talking initially about solar and solar siting and what authority the counties had on large solar siting facilities. But in the second seminar, because there was so many questions on the first hour seminar, they went into a second one. And the second one went into pretty deep discussion about also how the statute refers to how it entails and brings in the renewable energy of wind and where the county's authority lies. And it clearly leans on the statute and says, you know, the county, if the project is above 100 megawatts, it's PSC controlling. And they made it clear that they were, you know, when the legislation was offered, as the towns did, they registered against the legislation because they were in favor of local control. However, the legislature felt that and moved forward with it anyway. And so that's where we sit. If we have a issue, I think the issue is with the legislature and not necessarily with this entity. We may not like that, but that's what we have, and so the Wisconsin Counties has weighed in on it and said that where the county's role is limited to you know, a potential project under 100 megawatts. In potential conditional use permits and in our zoning code, but above 100 megawatts, it's clearly Public Service Commission. And if you do regulate it under 100 megawatts, it has to be in compliance with standards that are no stricter than 128 spells out.
Okay. We have another lengthy item to get to regarding the budget. So, final call. All right. Moving on. 7, policy issues, discussion and potential committee determination. A, discussion regarding 2024 annual budget and policy recommendations from the committee. I'm going to read these all right now so we can continue forward. 1, review of mandatory discretionary program document. 2, review of rates and fees document. And 3, review of 5-year departmental expense levy document. I know we have Chair Gibbs with us. Chair of Finance Robinson is joining us, and I'm guessing that's why we have some other staff members here with us as well. So I don't know how this discussion is supposed to start, but whoever wants to start, please feel free to go ahead. Finance Chair Robinson.
Thank you, Chair Lennon. This is our first time through, so you're literally our.
We're used to being pioneers around here.
We're glad that you're in that spirit, and just so we leave the wagon trains behind. But we are, as a follow-up to our 2 meetings on the budget process, looking to engage all of the committees in the process of evaluating the programs under their jurisdiction or their reporting relationships. And that includes a review of those programs that are mandatory versus non-mandatory, that request, you're looking at fees and other things, which you've done a good job of, and also look at the historic trends and then determining what level of service that you are interested in having the county maintain as we go forward. So we are, I think we're going to learn together, and I think that there's a good amount of information that's been shared with you in preparation for this meeting, and we'll look forward to a dialogue. I'll turn it over to Administrator Leonard.
I really don't have much to add. I think Chair Robinson, HR Finance and Property Committee Chair Robinson, did a nice job of laying out what I think are the 3 most meaningful policy-related questions from my perspective for you as elected officials, looking at, number 1, what programs and services do we offer? Now, a lot of that, as we've talked about before, is set forth by state statute, as this committee chair, Chair Langenhan, has noticed and referenced, rather, we are an arm of the state of Wisconsin in a lot of respects. So when the state says we have to do something, we have to do it. Now, that leads very nicely into the second question, which is they very often say we have to do something. Less often do they say exactly how you have to do it and at what level. So that is the second question. First question is, what programs or services do we offer? Second is, at what level of service do we offer them? That can mean a number of things. Do we have a targeted population we're aiming to serve with the program or service? Do we have a level of service in terms of quality or quantity that we're looking to serve? So for various things, that might mean like a turnaround time for the delivery of a service, or as the example I've given at relative to Infrastructure Committee, a PACER rating is a very easy to understand level of quality. We do an assessment of our pavement. Our goal is to have an average rating of 7 across our more than 600 county highway miles. So level of service is question number 2. And then the last question is, again, what HR Finance and Property Committee Chair Robinson referenced, relates to what cost. At what cost do we deliver these services? And for some services, as this committee knows very well, we charge a fee. And that, again, is something that you as the board, when you have the authority to change that fee, there are some fees you do not. The state sets them. But where you have leeway to do that, that's a perfect policy discussion to have, which is what level of individual or landowner or resident benefit is conferred by this service, and how much of that should be borne by that resident versus, if there's a public good, should it be borne by the taxpayers in general. So those, I think, are 3 prime questions for you to start this conversation, as was referenced. This is our first such conversation in this framework. You do have those documents that were within the packet, as we referenced in the large orientation and kickoff meeting. The hope is that they provide context. I also hope that you're going to have questions based on the information within those documents. We did our best to pull that information together. I can guarantee you, we've already caught some things that we want to make some changes, and we'll do that moving forward. I don't think they're meaningful, and we can talk them through if you do have questions, but we hope this is a kind of a conversational discussion moving forward. So I don't know if anyone else has anything. John, you have, or Kurt?
Not yet.
All right, that's all I have, Chair Langenhahn. Thank you.
Thank you, Chair. I'd like to add, Mr. Administrator, that we need a little bit more expansive role in terms of cost, and cost also needs to weigh the impact of what the tax levy is on county residents. You talk about the granular cost of the service, which is very valid, but I think we always need to look back at what are we asking our residents to pony up in terms of tax dollars.
If I can I follow up, I think that's a very good point, and this committee and every committee should absolutely do that. One of the documents we put together, we tried to kind of hit on that point, and that's the review of the 5-year departmental expense and levy document. Not only to show you kind of the growth in various areas, and for our departments, you can see where we've had increased service demands, and the board has recognized those with increased allocations in terms of budgets. But you'll also see, as the common adage is, not every dollar in the county budget is created equally. To Supervisor Sherfinsky's point, when you're looking at taxpayers, that relates to that far 2 columns on the far right, the levy as a percentage of the total department budget. So you do have a number of departments that have significant budgets. The best example is probably social services, which is on the next page. You'll see they have a significant overall total expense budget of just shy of $22 million. But of that, there is tax levy of less than 7.5 million. So you have those areas where fees and other state aids, other state revenues, shared revenues come in that offset costs. So they're not directly borne through the taxing authority that the county goes through every year through your property tax, but nevertheless, property tax, as Supervisor Sherfinsky pointed out, is absolutely a consideration relative to service level. It does impact service level. If you have a desire to have an effect on the tax levy, we can help you try to do that, but that's where it leads into that service level discussion and the revenue discussion. There's always the opportunity to try to, if something is supported by, largely supported by revenue, is it the right mix? Should you increase fees, increase rates? It's one of the things that staff, this is my last comment before hopefully others talk, but staff's approach to the budget every year is absent direction from you on each of those 3 things, those 3 primary policy questions. Our goal is do the same we did the year before in terms of the programs, the level of service, and the fees, and we accomplish that through trying to be as efficient as possible. So we're looking always, how can we make the better decisions on how without impacting your policy decisions on what services and at what costs and at what level. So absent you telling us to change any one of those 3 things, we're going to do our best to continue to deliver those same level of services, the same quantity of services as we did the year before.
Before we get too much farther, and people have heard me say this, people have heard me say this in the past, but, begin with the end in mind. So and I know we've had discussions about this new and improved process that puts more responsibility at the standing committee level, but I don't know if Finance Chair Robinson or Chair Gibbs can tell me here, but what is the end in mind with this process? Because what's been given to us as far as, and I don't mean to be critical, but you've given us a list of things, you've given us some statutes and some numbers for the past 5 years. That's all good information, but I feel very lost right now. And I'm the committee chair, and I don't like feeling lost. So please tell me where we're supposed to be going here.
I'll weigh in a little bit. I think what we heard last year from possibly new board members and some returning board members was they felt that they didn't have their voices heard as far as the impact on the budget. And so we had 19 amendments that were offered, and there was some impact on the budget. But I think it was brought in at a little bit of a haphazard way, and it was not looked at the way the board should be looking at that, and that is a policy. We are a policy board. We set policy. So in order to have an impact on the budget, rather than saying go and cut 10% from every department or a 0% increase, because again, every dollar is not equated out to tax levy, as you can see with CPZ. Prime example is their total overall budget's $4,831,479 this year. Of that, only 33% of that is tax levy. So $1,594,388 is the tax levy portion. And so we want to educate not only the board, but the committee. And if we want to have, when we get to budget assumptions, and we say we want and again, administration is tasked with developing that budget with the input from the committees. If we're not going to give them direction as to where to cut, it's not the board to sit there and tell administration, bring us back a budget that's balanced with $0 increase if we didn't give him direction as to what departments to cut that budget from if it's not doable with the funding that we have available. We have to provide, we as a board need to say, okay, guess what? We don't need to do nutrient management planning. I'm just saying that as an example. I'm not saying that that's the case. I'm just saying that's going to affect what kind of dollar amount in the tax levy. That's what this committee is in charge of, is those areas of jurisdiction that have an impact on the levy. So if the board overall wants to see a reduction in tax levy or a non-increase in tax levy, or specifically only an increase on net new construction that we can, the administrator can develop that. But he needs to have an understanding as, well, guess what? Does that mean that I go and increase the portion of health insurance that the employees pay to be able to balance that budget and still provide all the same services? Well, that's a total different project then, and there is ramifications to that action. So again, I think it's designed to have an input early on the budget that if we want an impact on the tax levy, where are we going to cut those services if that's in fact what the board wants to do? Or if the board does not want to do, doesn't want to cut those services, that's fine. Well, then the administrator has that direction. But without that direction, the administrator is going to do what he's done in the past, and that is, without any lack of any other direction from the board, he's going to develop a budget doing the same thing and possibly have to make adjustments someplace. But again, that's what this board's supposed to do, is provide that direction.
My comment was more or less directed towards the rollout process. You just touched on conservation planning and zoning has a 33% impact on the levy. We're trim. Could we be trimmer? Of course. I think I can't remember what county it is, but there's a county out there. They charge a fee 100% of the cost of the zoning application. None of it is borne on the levy. All of it is borne by on the applicant. I want to say that that application cost something like $1,000 or something like that. And that might have even been 10 years ago when I got on this board. So it might even be bigger than that now. I think that my comments are more directed with the rolling out of this, as I mentioned earlier. It's just that when you throw this amount of stuff at this group, and I don't doubt this, when I say this group, I mean all of the committees. I don't doubt ERC one bit, but there's got to be some direction at the beginning. There has to be, because otherwise, what's the point of having a finance committee? One other comment I'll make in regards of where we're going, and I like that I see the reduction on the levy continuing forward. One thing that I think this group can do, and I'll throw it out for discussion, everybody, I'll get to you in a second, Tony. We could start looking at the non-mandated programs and look at the balance between the fees that we charge for those and the impact on the levy. I think Supervisor Oberbeck, last month you had mentioned the relationship between fees and levy in the past. I think that's one way we can eat this elephant one piece at a time, so to speak. So, Supervisor Straczynski.
Thank you. And this is all, we're all trying to adjust. Some of us are new, so we don't have a lot of past experience. But I look at this from a policy perspective, and maybe I'm being somewhat simplistic, but that's okay. From a policy perspective, I think what we as an entire board need to think about, and this kind of walks itself back down, do we go bottom up from the committees, top down, or do we do it both and kind of meet in the middle? But we have to have the discussion that says, given our understanding of where our constituents are, current economic conditions, how they have been impacted, are they flush with cash, are property values rising, are we having poor economic times, whatever those impacts are, where do we think as a board we need to be in terms of an impact on local property taxes? Is that going to be, do we think a 5% increase is acceptable and justifiable, and we give that direction to the administrator? Do we think, on the other hand, a 2% decrease is justifiable? Do we hold the line at 0% or 1%? That's, in my mind, is a starting point to try and start giving the administrator and staff direction that says, here's what we want you to do. Here's the limit we're going to put on your increase. Then come back and tell us, how does that impact your ability to impact service and deliver service? You said, hold the line, no property tax increase. Here is the impact that's going to have on our ability to service our customers, the constituents of the county.
So how does this work conversely, by the way, if we have a good year and we're already providing a lower level of service? Like, are we going to have this great variance every year too? And I'm not here, I want to make this clear, because I voted for this process, okay? I supported this. I'm not here to kick the process that's been rolled out thus far. I just feel like there has to be some sort of reference point for us to start with. And I haven't seen that thus far. So now I've got 3 or 4 hands raised. I'm going to start with Finance Chair Robinson, we'll go to Administrator Leonard, then we'll go to Marilyn. Okay? So John, you can start.
Well, again, this is our first time through, and I think we're going to stumble before we walk. But I think what we're looking for is, an expression of priorities or other things. I think some of the things relative to the levy and that's dealt with some of our budget priorities that we'll do as a board in the next month or so. So is levy going up? What capacity will we be doing? So there's some broader discussions, but there are issues like Fenwood Creek versus Eau Claire, Dell's improvements to the camping. Both are under the purview of this committee. Is there a priority, or is one of more relative value? Do we want to go with more fees to support it, to allow for expansion of some of the park activities? I think those are some things that would be helpful in driving the budget that the Finance Committee doesn't have the time necessarily to get into all of those discussions. So we're looking for you. Are there some certain areas that are of higher priority to you as a committee to advance for consideration in the budget, which we've not done historically going forward. And, Lance may have a different spin on it, but I think we're looking for some of that bottom-up input early in the process to help frame that the administrator in the development of the budget and ultimately the finance committee and the board. So again, learning process, but we'd like that input.
Perfect. I don't know that I have a whole lot to add other than to HR Finance and Property Committee Chair Robinson's point. The levy conversation will happen. I think the better, this is my sense, is that the conversation might be more fruitful to start with the programs that are listed, because it's either a good thing or a bad thing depending on how you look at it. Wisconsin levy limit laws make the growth of levy very simple. Your operating levy is only going to grow by net new construction. It's only going to grow by maybe 850. In a wonderful year, maybe you'll hit $1 million of new levy. Your operational cost increase is going to be above that. The only way the levy is going to go up beyond that in terms of what you overall levy is if you do a couple of things. Library is above levy. EMS delivery is above levy if you want to get into that business. Bridge and culvert aid is above levy. And the last one is you borrow, but you can't borrow for operations. You only can borrow for capital. So the conversation here is really about, and at every standing committee, my sense, what are your priorities from a programmatic level? You are not required to do a lot of the things that you do. Quite honestly, this committee has oversight of a lot of departments who do a lot of non-mandated services. But I'll tell you, my sense, they're services that your community finds greatly beneficial. You brought up the Eau Claire Dells. You are not mandated to have the Eau Claire Dells. But I'll tell you that my sense, the community loves that resource. Solid Waste Department is here. You're not mandated to have it. But once you make a decision to have a solid waste department and do that service directly, you have a whole lot of regulations that come from it. So by no means am I suggesting that looking through these mandated and discretionary services that you're going to identify 10 programs to cut. My sense is there's a lot of constituents that look at every one of these programs and they're very, very valuable. But you should have the conversation. It's not staff's decision to say, we're going to continue to have a program, whether or not you have the Start Right program, which you used to have, or now it's the Nurse Family Partnership. If you keep that going, that is a programmatic policy decision. Staff will do the how. We will find out when we're going to deliver it, how we're going to deliver it, allocate staff. But you are the program policy board. Now, why that's important in terms of the overall budget is, again, Jamie's department, Parks, Rec, and Forestry, they do similar to conservation planning and zoning. There's a lot of other revenues that come in. So you need to balance. It's not simply a cost-saving measure to go in and start saying, hey, we're going to stop doing these things within our Parks department. But we're trying to help you make the most informed decision should you make a decision to cut a service. We're here to answer questions. But staff will do the programmatic pieces, or the service pieces, and we'll tell you that we tried to roll this up. I tried to roll it up high enough that you couldn't. I didn't want to give the impression like, hey, we can get rid of this program if they're directly tied to each other. If two things are really related, we didn't do highway lane wedging and highway maintenance. Those are all one thing. You can't separate them. But we tried to lay out at a high level what all of the programs and services are. So the levy conversation, or I would say the capital conversation for sure will happen at HR Finance. HR Finance is going to build other assumptions and the board will consider them, like the assumption relative to compensation. The board is ultimately going to tell administration what number to put in for an assumption in building the budget for employee compensation increases, because that is going to drive all of the other things. So it is kind of, to Supervisor Sherfinsky's point, and I'm going to paraphrase, it's like the chicken or egg, where do you start? But I think this committee, starting at the programmatic side, and we're here to answer questions, is a good place to start.
That was the same thing I was going to say, is on the levy limits, they're going to be here. They're not going to change. And you know that your costs go up. And I think about, shared revenues as an example. Towns have 28% of the population, but only 4% of the shared revenue. It's a broken system, and even there's some counties that get more than others, and the system needs to be fixed. But yet, we have to fix it, but the legislators have to fix it. And sometimes we don't have any control over that. But the main thing, like you say, is the levy limits in the smaller communities, or even some counties, you don't get much increase, but all of your expenses increase. So it's a difficult decision to make what your priorities are and what are you going to cut that might affect someone. That's the big decision that you have to make on the county board, is what policies are important, what is mandated, what are optional, and sometimes those optional help a lot of people. So it's a tough decision.
Thank you. And I think there's a way to do this, in that we know what's mandated, even those change as far as the emphasis or the priorities and how much effort you have to put into it. But as I've sat on the county board now for two and a half years, the priorities have changed. We've moved into looking at the water system, the water within the county, and that's been an emphasis through mining and how we're testing, and we're putting more emphasis on that. So the way we spend the money to do that has changed. So if the committee looks at those priorities that are variable, that change with how the county changes, and establishes those as priorities for the budget, and say we know there's an operating budget that we have to have for all the departments, and that's constant, or you want to keep that constant, but those priorities could be addressed by the changing dollars, and re-emphasizing it to how you do your own budget at home, as far as how do you address certain changes in your life. What changes in the county? What are the county supervisors bringing forward as a whole that need to be addressed by this committee? And that could be prioritized, and that's how we develop the budget each year. So I think that could be a good way of looking at this, is we know the money is not going to change that much, but how do we use it? And how do we set those priorities based on what we hear out in the community or what we see coming forward? So I think that would be a good means to start moving forward.
I guess my only reservation with all of this, you've heard some of my other reservations this afternoon, but if it's bottom up, and I respect that, I think that's a good way to do it. You're also asking us, to do a pretty rigorous evaluation, which is fine. Like I said, this committee will do it, but going through this program by program, you do a priority by priority. I'm throwing this out there for the sake of the committee, because you can see there is a lot of stuff here. And even if something isn't mandated, like I said, I think at the very least we have to start asking with the non-mandated stuff, like I said earlier, fees versus levy, the reliance on that. I think another thing that we need to look at is if you go and look at these programs that we are required, what is the baseline service level that we're already providing? But there are a lot of programs here, and the administrator starts his budget assumptions in August.
No, we're starting that conversation this month.
So how do I say this? Your numbers you get though in like August, right?
Oh, yeah,
Preliminary
numbers come in at various times of the year. I mean, we really don't have our, provided if we make a change on health insurance, the story is different, but we don't have our final health insurance numbers till later in the year. Shared revenue has historically moved quite a bit in terms of knowing what for sure our GTA is going to be. I mean, quite honestly, we got that a couple of weeks before the budget was completed. So to your point, yeah, the numbers change. The big assumptions we're going off of in building the budget are going to be sales tax revenues. It's going to be a big one. Compensation is an expense budget assumption that HR Finance is going to develop recommendations for the full board on, as well as healthcare delivery costs, figuring out what assumption to build in. Because departments have control over a lot of things. They don't have control over what you as a board are going to set in terms of compensation increases. They don't have control over health insurance. They don't have control. We don't let them manipulate the personnel side of the budget. We let them manipulate the operations side. Their job is to dive into the same line items that all of you saw, when I sent the 616 page, I think it was, or 627 page line item budget. We look at every line. How much is in there for, do we have the right amount for training? Do we anticipate increased costs for certifications, or how's our revenue looking? And I'll give an example in the Register of Deeds office. We know revenues are starting to slow in the Register of Deeds. Fewer land transactions than had been happening over the last several years, which in some respects is a good thing, because there were a lot of land transactions that were happening that were pushing our staff to compile a lot of work that they hadn't historically. So all those things we look at as staff, but that's with, again, the message from the board, as Chair Gibbs said, that's what we do if you tell us nothing else. If you can look through this, I believe it's 49 pages or 50 pages, the mandated discretionary list, if there's something like, you know what, we shouldn't do that, that's the low-hanging fruit where you can just tell staff, hey, we're going to make a resolution to go to the full board for consideration to stop doing program X. And then staff will build a budget. If that passes, we'll build a budget that doesn't do that. But absent that sort of direction, or you want to add a new program, as Supervisor Oberbeck referenced, if you want something new, like you have new priorities that are rising to the top, tell us what that is. Tell us what those are. We can develop some sort of plan to address your priority, and then you can weigh how do you fit it in with your other priorities, and what are you going to do less of if it's going to require tax levy. So right now you maximize your operating tax levy every year, like every good county government should. Otherwise you're not, that's the smart fiscal thing to do. Otherwise you just add costs to the taxpayer in a different way. So you're going to need to make those choices if you do have new priorities. But we can help you bring information to the table to do that.
I think the other thing that would help would be if staff would bring forth trends, just what you were mentioning about land transactions. Whatever affects this committee would be very helpful to know what's going on at the county level, so we can address those priorities or what we're going to react to. We need to know that information.
As far as where we go from here, I'm trying to rebalance myself. I think that the trends point is a good one. If there's something out there that staff is aware of course, we would appreciate knowing it about it, what might be going on, what opportunities there could be there. The other thing I noticed, and maybe, again, this is feedback that Chair Robinson or Chair Gibbs can take to another committee, but we provide oversight for Park Commission, Forestry, and Solid Waste, right? They come to us. If we start making decisions, and I guess what I'm saying is that what input would they provide then, right? It seems like we're superseding them then. I don't know what the relationships are in the other standing committees with those other oversight committees, but that's something to think about. I also would like to throw out there, I know Jamie had to leave, but I also would like to look at what is the philosophy behind charging for fees in the parks operations. Because if you look at, like, you know, when I was reviewing this, I saw there's a lot of no's in that park document, a lot of them. Politically, is that a good idea to cut your entire parks department? Probably not. But is there something, there's an opportunity there that we could put that more on the fees that people pay when they use our facilities? But again, I don't want to do that without having input from the Park Commission. Mr. Leonard?
Thank you, Mr. Chair. That's a great point, and that is actually something that I understand the Park Commission does on a regular basis, is look at those fees. But to your point, having a conversation at Park Commission with some input from this committee and the full board, what is the philosophy? Some of our park fees are set to be 100% cost recovery. We generally refer to them, much like solid waste, as an enterprise fund. Does it independently operate? 9 Mile Forest is an enterprise fund. It has revenues necessary to, the goal is revenues necessary to meet expenditures, but that's not the philosophy with respect to all of our park fees. So that's a great area. We can have Jamie specifically sit down, and if you want to walk through, and she can give an overview of the philosophy that the Park Commission has used in setting those fees. You're not unusual, this standing committee, compared to others, in that the program committees have a fee-setting responsibility. I believe that's the case with solid waste as well. Dave works with the Solid Waste Board, Solid Waste Management Board, to review those fees. The Board of Health looks at the Health Department fees for the various programs they offer. So I think as it relates to conservation planning and zoning, however, there's no such program committee. So this is a perfect example to, if you have questions, when you look at that document relative to the fees for service that we're currently charging, staff can give you that information to help you understand what that mix looks like.
So how about this? And I also want to talk about timeline, and I don't want to keep us all here past dinner, but that's another discussion we have to have before we leave. Park Commission, I would like to see that from their department to talk about their fee philosophy. As for staff with conservation planning and zoning, what I would like to see from their department, examine those non-mandated services. And like I said, I know I've said this like 3 other times already, but I would like to see the relationship between fees and levy there. Maybe there's a chance we can go under that 33% reliance on the levy through that. Trying to think what else. Solid waste, Dave. Yeah. Do you have 100% cost recovery in your department? Is all that covered from tipping fees, or do you have a reliance on the levy at all?
We have never relied on tax levy to date, so everything has been enterprise fund. Why am I here? Well, it's a program. Obviously, it's a. What's that? Solid waste is a program. It's not mandated, but it's one of those. What service do we want to provide the community? Do we want to make sure that the community has a proper means of sanitary solid waste disposal, a system in place to ensure that we have that very important part of our community, and not only for the residents but also the businesses, right? So,
Sure.
Wanted to make sure that if there were questions associated with it, I'm here to help answer those.
Okay. Brian, sure, Robinson.
I'd just like to pick up on why is he here. In Lincoln County, the Lincoln County Solid Waste Management Program makes a contribution in lieu of taxes to the county for their operational budget. That may be something that may come out of this. So they make, I think at one time it was a $200,000 a year payment. Dave probably doesn't want me saying that, but that's one of the things that may be on the table if you wanted to look at ways of having some of those enterprises support the ongoing operations of the county.
Well, the cat's out of the bag now. Staff is going to look into that too. I mean, I'd like to give some sort of assignment. And again, if the committee doesn't like what I'm saying, please interject. I would like to give each department some sort of assignment for them to bring back that next month. That way they have direction. So Administrative Laird, then Supervisor Ritter.
I don't know that I'll keep the cat analogy going, but Dave and I we're talking about exactly what Supervisor Robinson referenced. And this committee is very well aware of a lot of the work we've done just in the last, what month is it? May? The last 6 months relative to some of the partnerships we have out at the Solid Waste Department to renegotiate those and bring in additional revenues. We are evaluating exactly what Supervisor Robinson referenced to make sure that not only does Solid Waste Department continue to operate as an enterprise fund, but what opportunity exists for us to adopt a very similar model where there's essentially a payment coming into the general fund from those enterprise funds. Solid Waste is the best example of a highly successful enterprise fund to offset some of those operations.
Okay, Supervisor Ritter.
Real quick, this will probably be more clear once we do get more information from the different departments on their philosophies. But if we decide as a board to say, let's have them raise fees at the parks, it's hard to measure how much tourism revenue are we going to lose.
Sure.
You have a local bait shop owner, he doesn't want his taxes to go up, but he also doesn't want to lose half of his business to a neighboring county because they're cheaper.
Yep.
So it's a hard thing to measure, but it's something we have to keep in mind.
Yeah, definitely. I think, and again, I think Supervisor Overbeck touched on that a little bit last month where he brought up that ratio, or maybe not specifically, but I think it was alluded to in your comments as far as, it's still ultimately a cost. And is it a question of service or is it a question of cost, right? If you want to have lower level service, sure. But then you have to have this balance of, well, would people be willing to pay that in order to maintain the service, right? And that's fine. Like I said, I think we have to look at that philosophy first before we start talking about that, which I'll get to another comment for staff, but Marilyn, you first.
Tell me, how many counties use the Marathon County Solid Waste Department to put stuff in there? I know there's more than
one. And can we charge them more?
Certain townships, maybe.
Yeah. Oh, jeez.
As many might know, the solid waste system is a very balanced, since we are competing with private sector. So you do want to use some caution when you start talking about rates that you're charging not only the municipalities that we partner with, but also those private sector businesses. For example, Waste Management, one of our great customers, also our greatest competition with a landfill located right in Wisconsin Rapids. So there's definitely that consideration. You want to make sure that you're balancing those. And to your point, Marilyn, yes, we do take waste from outside Marathon County. It's very important that we maintain a certain level of tonnage that's coming in because of the costs that we incur. There's large landfills and there's smaller landfills, and there's not a lot that are in between. We're kind of on that larger scale because you do use that economy of scale as you fund your fuel and your engineering costs and your clay, all those different items that you have to input when running the landfill.
How many counties bring stuff to there that you have contracts with?
We have contracts with Portage, Marathon, Shawano County. So it's a 3-county agreement.
Okay. Timeline. Obviously, we have to pass a budget in the fall, but as far as providing this determination from the committee to the administrator to wrap this in as part of the budget process, what is this group looking for?
Well, that's a great question. As Chair Robinson referenced, HR Finance and Property Committee Chair Robinson referenced, this is our first time. My sense is the first thing I would need, the highest priority item is if there is clear direction that on the program side of, hey, we want to stop doing program A, but we want to add program Z. Those are the types of things I need to know sooner rather than later. The fees, that can go further on in the budget because that can be a conversation that we as staff look at and say, okay, we've gotten this direction to make these fee modifications. What is that going to do to the revenues and to the expenses? Hopefully it doesn't add much to the expenses side if we're just making a change relative to the fees that we're charging for a service. But if you're making a fundamental change, like, you know what, we don't want to deliver, again, a certain program that is not mandated, that is something that we want to make sure we start those conversations early, because there is an analogy a colleague of mine uses that, you know, when you pull on one string, right, the budget is a ball of strings. You pull on one and you end up yanking out a bunch. I'll give you an example. There's a program within our social services department that's 100% tax levy funded. And you might recall from that sheet that's up there, well, Lance, you told me that they're only 34% levy funded. That's true. Not every program within every department is funded at the same percentage. The same thing is true for CPZ. They have certain programs that are more grant funded than others. And this program within social services is, for example, the whole point is to work with families to keep them out of the child welfare system. So it's early intervention, family coaching, those sort of things. Yes, that does come at a tax levy cost, but all of the data that we've looked at outside of our organization and our anecdotal experience within it is that it saves you more money on the back end because you're not having to do as many child welfare placements that are more tax levy, that are perhaps less tax levy funded, but they're more expensive. So it's kind of that investment piece that we talk about. So if you want to have those conversations, and that's why I know it's a lot, to Chair Langenhan's point, there's a lot of programs and services. I tried to make it as high level as possible. If you have questions about, hey, what does this program mean? That's kind of probably the first place to start. Staff can help you, give you kind of the Reader's Digest version of what a program is, and you guys can continue to ask questions. The fee piece and the service level piece, I think, can go off a little bit more. Maybe that can wait 2 months. But in this meeting and next meeting, it's really that higher level. Are we going to get out of any business, any business that we're currently in? That would be very helpful to know earlier. So then we can build that once if the board approves that direction, we can build that into the budget.
So I have to write down some thoughts here. If somebody else has a comment, go ahead. Supervisor Overbeck.
I was just going to mention, based on the economic data as far as not only going down, but what can go up, and I think the Economic Development Committee can drive some of this too, as far as interaction between the other committees. You know, what happens if we put more money into our parks? Does that increase the usage of them? And the fees, even though they may stay the same, increase the usage, and all of a sudden you have more fees coming in. So it's got to be looked at, what do we invest in the county also to make it better? And, you know, we heard with what we're doing on the old plain with aeration and whatever, that we have a world-class fishery as far as what can be done there. I didn't know that. I wonder how many other people don't know that that's quite the asset and world-class. So, you know, is there money to be invested there to bring in, for an example, more tourism or whatever that spend money in Marathon County, drive up our sales tax? So there's things that can basically snowball into better things if we do the right things. So that's something we should consider.
Here's where I'd like to end the discussions today. And again, I mean, interject if I'm reading this room incorrectly, but this is what I would like to see going forward if we're going to have these type of discussions. The very first thing is that I think each one of these program departments should have some sort of work directive given to them. Thus far, Parks and Forestry have been given the directive to look at their fee philosophy and specifically look at the Park Commission, what they do. Conservation Planning and Zoning, I'm actually going to expand the ask from not just the non-mandated program fees. I'd also like to know the service levels for each of those non-mandated programs. And then for solid waste, you figure out how to pay us, basically. Okay? So that's the first area. The second thing is general program discussion, which I think is, now I think I'm understanding this a little bit clearer, what the purpose of this list was. And I had some questions going into today, but again, I was unsure of process. I think I have an idea where we're going. And really what I would like to do is keep this list a part of these packets going forward. And if you see something in there that you would like more information on, I just ask that you please contact staff at least a couple days ahead of time before this meeting so that they can bring that information to us. Because if there is an ultra-specific question, I don't want to sacrifice time for us to have to wait a month in order to have the answer to a question. So let's all just sort of get this idea in our heads that if we have a question about a specific program, I've got one about the icing thing at Marathon Park that I want to bring up to Parks Department, that please try and contact staff ahead of time so they can bring that information to us at the ERC meeting. That's the second thing. And then the third thing is, to the administrator's point, that overall fee discussion, that might be in the background. You can certainly see that we've been talking about fees for a couple of these topics already, but to Supervisor Ritter's point, I think that's a necessary part of this discussion because that lends itself to the service level. And if we're going to talk about service level, I also think we have to talk about the fees as well. So it might be in the background, but I think it's something that this group is going to be talking about quite a bit. So those are my 3 ideas. Is there anything else this group wants? Of course, this can change. This can change. Okay. All right. Now you guys are going to have to take this and use it as a template for the rest of the standing committees.
Good job, pioneers.
Well, because otherwise, like I said, in all seriousness, a guy feels lost. You know, here's a list. You know, what was the guy supposed to do? All right?
Everything is fine and we're good.
Yeah. You know what? I'm gonna stop now. I've said enough today. All right. Lori, did your staff have anything, or is everything good there?
I believe we got the questions down. I think we understand what you're asking. I will clarify with you if we need further clarification, though. So.
Sure. Okay. All right. 7A, 1 through 3 are done. 8, next meeting date, May 30th, 2023, 3 p.m., Assembly Room, future agenda items. Of course, we will be bringing back the budget discussions. Committee members are asked to bring ideas for future discussion. B, announcements, requests, correspondence. 1, Conservation Planning and Zoning staff will testify at the state legislature on the Fenwood pilot, May 10, 2023.
Yeah, so the bill is before the state legislator, and they did invite us down there for May 10th to testify. I think Kirsty Heidenreich, our county conservationist, had emailed ERC about that if anyone wanted to go along and be part of that as well. So.
Okay, thank you. Any questions? All right. 9, adjournment. Motion by Seefeld, second by Vensky. Any further discussion? Hearing and seeing none, all those in favor signify by saying aye. Aye. Those opposed, motion carries. Go home.